lady. But I suspect what my colleague was referring to would be the paragraphs when one has regard to paragraph 44 of the founding statement. My lady, he says that from the period of December 2022 to until May 2023, there were two other signatories. He further says, I thus state, thus the state's allegation that during the said period, the 100% shareholder of Erongo is infactually correct. My lady, I would like to take the court to the founding statements on page 3727. That's the first founding statement that indicates that the third appellant was indeed 100% owner or had 100% interest in the closed corporation, and that's effective from 10 May 2022. And there is, my lady, a further founding statement on page 3731, if I'm not mistaken. The numbers is not clear. That would be from 27 October 2023, my lady. Now, my lady, what the state fails to consider, and this was canvassed initially between Ms. Gebhardt and the investigating officer, is that, my lady, when you have regard to page 3736, it is clear that those members, my lady, only ceased to be members as of 27 October 2023. And that is why he says there were still other signatories, my lady. And it's clear from the Bieber documents that they only ceased in 2023 to be members. Further, my lady, I invite the court to have regard from the record from page 1969 to 1974, where this issue of ownership and when they ceased to be members was asked from the investigating officer, where he said he did notice that, but he was comfortable, and what gave him comfort, if I quote him correctly, was that Mr. Nandaho was a member, and because of that, he did commit or made the payment of 500,000. The record would reflect in that regard, my lady. My lady, I submit that we did deal with the issue of the typographic error with regards to the ownership of the closed corporation. The state has not engaged that issue at all. That issue stands on our version that it was a typographic error, my lady, and that he did not intend to mislead the court whatsoever. Beyond that, my lady, I have nothing to say regarding that issue. My lady, the issue then that I would like to deal with is the issue of public interest. Your ladyship would have noted that we dealt with it in our heads on paragraph 14. And I would just like to draw the court's attention to paragraph 39. Sorry, my ladies, it's page 14, paragraph 49, where we quote the case of S versus Gustavo that my learned colleague relied on. And what my learned colleague, I do not know whether it was intentionally, but what my learned colleague left out is point 3 of what the court says. The first is that the concept is wide and difficult to define. That he said it. It further says, its purpose is to combat crimes and ensure the proper administration of justice, particularly in respect of serious crime. This is the Supreme Court having discussed section 61. The court further says, in essence, the concept of interest of the public and administration of justice serves a broader safeguard to ensure that releasing of an accused person on bail does not undermine the integrity of the justice system or undermine the public trust or the fight against serious crime and impactful crimes. That's what the court says, my lady. My ladies, and I would like you to just park that for a little while, and as I make the following submission. In the case of S versus Essex that we quoted yesterday, my lady, the court found in favor, holding that before it can be said there is a likelihood of justice being frustrated, and this is the integrity of the justice system. it was required that some evidence or indication that touches the applicant personally in regard to the likelihood must be placed before court. This is the balancing act that the court needs to undertake when it comes to public interest, my lady. And as we submitted yesterday, there was a failure by the magistrate to then conduct that balancing act. My lady, further, I would like to refer the court finally to the case of Water versus the State Charlotte Water. We also made reference to it yesterday, my lady. Specifically, unfortunately, it's a 1995 judgment, my lady. It does not have paragraphs. I will refer the court to page 22, 23, and 24 of that judgment, and specifically page 23, pardon me, my lady, page 22 towards the end. It would be the last paragraph on page 23, pardon me, my lady. The court finds and says, in my view, the magistrate in the first application for bail was near the mark when he said in his judgment that the interest of the public can be equated to the legal convictions of the community. My lady, this judgment was in 1995, little years after Section 61 was introduced. And the judges at the time, my lady, it was Judge Olin and Judge Hannah. They then go and say, in my view, the legal conviction of society encompasses the legitimate, reasonable, and justification values and expectations, fears of a law-abiding member of the Namibian society as entrenched and protected in the Constitution of the Republic of Namibia. With due consideration to the corresponding and relevant values, expectation and norms, perceptions and fear of capable civilized society and the community, my lady. It goes further and says that the legislative amendment referred to, and this is Section 61, provides that it is in the interest of the public and administration of justice as seen by the judicial officer, i.e. in his or her opinion, which must be decisive. Such judicial officer will therefore obviously have to make a value judgment, and this is what I referred to yesterday, my ladies, of what these legal conviction of society and what is the impact of such convictions on the particular case where the court must adjudicate on a bail application. My lady goes further and says that the legal conviction of the community, in my view, will hold that an accused should not be released on bail in a sketch situation, provided that there is evidence presented, my lady, or prima facie proof against that such person that if he or she has committed a type of serious crime discussed is, pardon me, my lady, it's an old judgment, it's not quite clear, if I may, provided that there is prima facie proof against that such person that he or she has committed the type of serious crime discussed is therefore, in the opinion of the court, a potential threat to the victims or other innocent members of society, or is perceived by them on a reasonable ground to be such a threat. Now, my lady, all of this, and I say this judgment is right after 1995, attempted to define what factors must be looked at. And we submit that in this present matter, my lady, and also staying with the principle of S versus Isaacs, there was nothing presented by the investigating officer that touches the third appellant or any appellant in this matter that it will not be in the public's interest or administration of justice, my lady. And further, again, we state that the magistrate only considered one fact, that this case has been it's been live streamed and enjoyed some sort of publicity, and that's it. There is no reason stated why it would not be, why the integrity of the justice system would be undermined by releasing the applicants at the time. My lady, I have 5 minutes and that's my time. As the court pleases.
Thank you. Mr. Isaac?
Thank you, Malaysia. I will be very brief. Just want to ask one thing, that I'm not being accused of witchcraft, because I will refer to a decision by the court where Justice Christian was part of the judgment, and I want to refer the court to page 63, it's also part of the paragraph 63, that the whole notion of
Which
the
page is
issue of
that?
61 is that
Mr. Isa? Which matter?
63 paragraph
The name of the case.
was. My apologies.
At least it's you referring to it and not Judge Christian.
Judge Christian was not a party to this, he was presiding officer, just to make that clear. It's Kluter versus S. It is a recent judgment in 2025. And on paragraph 63, it was held that the provision of section 61 are indeed not easy hurdle for an accused person to cross. And that's why the safety mechanism is built in. And in fact, this matter referred to the Namcor case, where it was held that this duty is upon the judiciary and the prosecutor to ensure that it's particularized. And the court held on paragraph 68 that the failure to define and apply, as Justice Rakau indicated, is not only in the beginning but at the end of the trial that you are informed. So the failure to define and to apply, where Justice Christian asked how did they do the balancing act, the presiding officer, public interest in state of justice with reference to the appellant's circumstances amount to a material misdirection. And on that basis, my ladies, I submit it's time for the appellants to go home. As a court, please.
Thank you, Mr.
Since our colleagues are rushing for Friday, and I took out on the wayside of still getting my ducks in a row. Maybe let me start with an aspect, my ladies, that was raised in my absence. So it appears in my absence, my learned friend had the courage to say I engaged in hostility with the witness, whom I described as being hostile. And I don't know, for some or other rather painful and sad reason, the simple English word nonsense has been devoted to such a horrendous word. A lady, I engaged that witness squarely on an issue. And you would no doubt note from the record where this issue arose. And my lady, the witness is simply told, I mean, this is on page 1892. And surprisingly, this magistrate who lacked the courage, when invited to do so, to call to order this witness, had the audacity to call me to order. But let's engage in what is contained on that part of the record, my ladies. Your Worship, we have already established this behavior, and that is referring to the behavior of the witness, by the way. And we are not going to condone that behavior by this witness, Your Worship. If he does not have an answer, he must tell us he does not. But I'm not going to allow that nonsense. And for some or the other reason, this beautiful English word that we use in common language is perceived to be an insult. And my colleague in my absence has the audacity to suggest that I engaged in hostility with the witness. Then maybe this is the time today that this court will correct me and tell me the use of the language nonsense is offensive. And I beg to respectfully disagree. Now, and then, my ladies, it is suggested that you should not just look at the $10,000 that is said to have been paid to the fifth appellant. And it is suggested that, the first appellant played some or other central role when the memorandum was prepared. Let me invite the court to paragraphs, and that is on the record at page 3627, paragraph 22.4 in this instance. I'm just briefly going to read it, my ladies. I am unaware of any sale of 9 service stations. As far as I'm aware, there was an asset purchase agreement concluded between Namcor Trading concerning the right, interest, and title to assets owned by Enercom. The transaction in question was foreshadowed by this fuel supply agreement dated 16 March 2022, in particular clause 4.5.1. I state further that I was in accordance therewith tasked by Davis Maposa to prepare the internal memorandum dated 8 July 2022 after I had occasion to consider the valuation report prepared by Mr. Shifeni, as well as the financial feasibility study conducted by Mr. Sem Hashela. I'm going to stop there. And I had my learned friend to submit, and it appeared strongly so, that sometimes the scales of justice do not balance. Then, if that is the case, then we have a big problem. You are told, and in fact the investigating officer was engaged on this aspect and told, but Davis Maposa, where is he? Why is he not in the accused person's door? So the same with Mr. Hashela, the same with Shefeni. If that memorandum was the trigger point, what about the feasibility study? What about the asset valuation that was conducted? Because you are informed. The reason for the preparation of the memorandum is on account of the valuation and the financial feasibility study that we were presented. So surely that must then be the trigger point of all things evil in this matter that the state is complaining about. But no upheaval is made about that. My lady Justice Christians, you observed what had been said about this valuation report and feasibility study being a sham. Unfortunately, it was not categorized as a sham in these criminal proceedings, but in a related, of course, civil proceeding. Insofar as these proceedings are concerned, it would appear that those characters, I dare not again mention their names, were equally complicit, yet they do not stand where these accused persons are today. Since we've become very fast, my ladies, let me also just fastly move to another aspect. Now, I note that this court was referred to the authority of Chilwane versus the state. May I record, my ladies, that this appears to be a High Court authority, and it's a High Court authority from the Republic of South Africa. I have not seen my learned friend take this court into confidence and tell this court that the authority I'm relying has actually been received with approval by a court of equal standing as this honorable court.
It is a very recent judgment.
Indeed, it is. Yes. It is a very recent judgment, and I mean, I have not even heard him tell you that there is any persuasive value this authority has. For all intents and purposes, my ladies, it is a court that is of equal footing with yourselves. And you will not be wrong if you disregard it, my ladies. But even if we are to consider it and take it into account, selective reading is a very dangerous thing, I submit. Because even if we are to take that very authority into account, it says a charge sheet should contain sufficient particulars in order for all parties to assess what schedule the bail application will be dealt with under. I mean, it says sufficient particulars. And where we complain about the charge sheet, where the charge sheet at some point categorizes the Namcor employees as victims, and in the one sense then they become the culprits. I mean, surely that is the belly of the beast. That is the introduction an accused person has to at least appreciate what is the case he or she has to come and answer when she comes to court. And if it is so bad, surely it should receive the deserving criticism. And lastly, my ladies, and this is the one thing I was saying that really stresses me and worries me. It's about the development of terrible jurisprudence when it comes to bail considerations and amounts to be considered in bail. I heard my learned friend tell this court that, the court should look towards the amount that is claimed to have been embezzled or whatever the case may have been. If that is the jurisprudence we are going to start in this country, my ladies, then the observations made yesterday by Justice Rakau no longer exist in the minds of judicial officers, because we must get carried away by amounts that are suggested to have been embezzled. What then? We have people who receive bail for murder. We have people who receive bail for rape. There are no values attached to that. In fact, in instances in our courts, my ladies, people accused of heinous crimes such as murder have received amounts as low as 2,000 Namibian dollars for bail. So what then do we say? If we are going to say the value considered for bail should be somewhat commensurate to an amount alleged to have been embezzled.
Mr. Casper, I didn't understand the prosecutor to say exactly that it must be equal. I understood that it is one of the things that you pack into the decision. So I understood him to say it's one of the things that you look at, not that it's the only thing that you look at.
I completely understand and appreciate that, my ladies, and that's why I'm saying it's an allegation. As Mr. Namcor had even submitted in court the other day, we were told it's $480 million, my ladies. The amount just kept changing. That's the problem, my ladies. We cannot look to that aspect. We should remain guided by the well-established principles concerning consideration of a bail amount, which is what your lady Justice Rakau, reiterated yesterday. That's really the bottom line here. But my ladies, I want to put you in a difficult position, and I want to make a further submission. And I want to say to this court, given the appreciation this court had on the first day when we set our foot in this honorable court, and it somewhat excited me that the courts again appreciate that bail by its very nature is an urgent matter. It concerns the liberty of people. I want to say to Andy, submit strongly so to this honorable court. If this court is with us in respect of the mishandling of the bail proceedings in the court of code, I want to invite this honorable court to give us an extempore judgment and the reasons to follow. Those are my submissions. The court pleases, unless there is anything the court would like me to address it on.
Mr. Casper, since you've put a difficult question before us.
Indeed.
According to your submission.
Yes.
I want to throw it back to you.
Yes.
Do you have authority for the court to give an extempore judgment?
Well, yes, my ladies.
The extensive reasons would follow them.
This is something that happens every day in our courts. Last week, I think it was 8 February or so, I had the pleasure of appearing before Justice Sibea in relation to an opposed motion. The court then and there, in fact, he gave 2 judgments extempore. And there is nothing that impedes this honorable court to do so, particularly given the issue that this court is served with, that is the personal liberty of accused persons. And if this court were to be convinced that they were wrongly deprived of their liberty, this court can do no better then letting them go home, as my learned friend was like, is
Those
acceptable.
matters comparable to the complexities that we are faced with in this matter.
My ladies, that's why I said,
Yes.
from the observations I made in this court, and the concerns this court has also correctly addressed and raised with the state, I do not see any further complexities here. I honestly cannot see any further complexities here.
Thank you.
As the court please.
Mr. Simonye?
May I please the court? My ladies, I'll start off with case law. Case of State versus Ngikulifa. It's a judgment of this court, CC02 of 2014, which talks about submissions and arguments must be based on admissible relevant facts and not a speculation or irrelevant material. Now, the reason why I'm starting off with that, my ladies, is that obviously as legal practitioners, we are bound to make our submissions on what has been adduced. In this case, it's the bail application, so we are bound to the record. Now, it's so sad to learn that, submissions can be made contrary to what is in the record. And I'll become more specific. My learned colleague submitted that my client, Appellant 6, involvement as a signatory in account 520, didn't yield any amount. Nothing came out of it, in other words, which is not true. When we submitted yesterday, which is contained even in our heads of argument on page 10, the involvement of my client as a signatory of 520 account was to guard and to safeguard the interest of Namcor. And she ensured that an amount of $10,224,198.81 was, transferred to Namcor. That is her involvement. Of course, Justice Rakau already pointed out the issue of the asset purchase agreement. Based on that, 35 million went to Namcor. Again, this was to safeguard the interest of Namcor. So to parade a narrative that she became a signatory in October 2021, but nothing happened, as based on the asset purchase agreement is not correct. The figures are there. The evidence is there. In other words, she did her job. And in fact, I'll extend it further, Your Ladyship, to say that there's another narrative that was paraded, that this issue of conspiracy. If indeed Appellant 6 was conspiring with all the other people, including the owners of Namcor, Appellant 1 and 2, why would Appellant 6 suspend, the credit, the issue of Appellant 1 and 2 obtaining fuel or credit, which was done? And this is on record. My learned colleague, I would like to believe, conveniently, he left it out because he was cross-examining my client. That is on page 1342 of the record, 1342, where this issue of this allegation of treating Namcor as a special child came in, and my client explained clearly that Namcor all along was paying, but they started defaulting in October, November 2022, and their account was suspended. It's on record. So why would you suspend an account of a person who you are conspiring with, a person who or persons who you are treating special? It does not make any logical sense. But that was what was mischaracterized, and thus I have the obligation to correct the position. That is not correct, and that is why I refer to that case, that we must make our submissions based on the evidence that is before the court. Now, the second aspect I'd like to deal with, my ladies, is the case that my learned colleague quoted, the Chilwane case. I take into cognizance the recent judgments, the 2025 judgments. But he earlier referred to an OSF, state versus OSF case, and then he withdrew it. Why? Because he realized by the questioning of this court that what he submitted there didn't make any sense. So what was the purpose of putting that case? is to try to mislead this honorable court, and I say that with respect. Because even from Justice Rakao's response on the issue of the child protection, is it the Child Care and Protection Act? Of course, we didn't cite that act explicitly, but we cited the Constitution. And from the constitutional provisions that we cited, they talk about protection of children, and that it's the best interest of children that have to be looked at. So it ties within that. Now, getting back to the Chiloane case that my learned colleague is talking about, your ladyship, with the greatest of respect, and I'm tying this to the Charlotte Helena Bota case. If one alleges there's a serious case and they have a strong case, just like the state alleged in this case, you must be able to show that you have a prima facie case. Did they do that? Absolutely not. What prima facie case have they been able to establish against my client? None whatsoever, apart from parading narratives that they couldn't prove. What conspiracy, what evidence of conspiracy did they come up with? Absolutely nothing. And again, I reiterate, my ladies, what wrong did Appellant 6 do in the exercise of her duties? Absolutely nothing.
But
Why
she's not
isn't-
charged with that.
Pardon?
She's not charged that she mis-executed her duties. She was charged she benefited from offences, yes, or proceeds of crime.
My lady, there's the other aspect of the conspiracy. Because the state is alleging there was a whole conspiracy. So she conspired with other people to favor Enacon and to ensure that the asset purchase agreement, payment is done so that she can benefit. That is the whole narrative that they're trying to parade. So, my lady, with respect to what I'm saying, what wrong did she do? In terms of her role, she got a memo which was approved by her MD, her boss, with supporting documents, asset valuations from the engineering department, Nesta Shefeni, heading that department, who was the co-releaser. Another independent asset valuation from independent engineers, CEO contracting engineers. Just that on its own shows that everything was above board. She had the supporting documentation. But the other aspect I'll address, she even went and checked the budget of 2022-2023 to see whether the amounts have been approved. And there's the other aspect which my learned colleague is not mentioning. It was only mentioned in regard to, I believe, the fourth appellant. 25 million is budgeted for asset purchase, but there's the issue of 40 million for business development. It is there on record, we've indicated it. Where my client
Mr.
even
Simonyo,
explained.
sorry to interrupt you. We have not heard anything with regard to the submission by the state that she, in actual fact, benefited from the money that was paid into her home loan account that she co-owned with her husband. Because that is a specific benefit that was pointed out. Now, you haven't addressed that in your reply, that
My lady-
specific allegation.
My lady, he indicated she benefited indirectly. That is what I heard him say.
I think if my home loan account that I have together with my husband goes down with 600,000 plus, it is a direct benefit actually for me because I owe less on my home loan account.
Yes, my lady, but the exact nature of that benefit, how, with regard to what were there any arrears before that payment was made, and so on. That information didn't come out, my ladies. But the issue is, the crux of it is, that is the only narrative that the respondents want this court to believe. How exactly my client benefited indirectly from that is not coming out, just because she's the co-owner of the house. My lady, one can even throw a rhetorical question. What about if she's the one who has been paying all along and accused 8 was not paying and now he paid what he was owing? All that can come up So when you parade that narrative, you must adduce evidence to show how exactly the person benefited. That is not coming out. So I'm
Yes,
leaving-
but what I'm saying is that is the allegation by the state. That is where the benefit that they pointed to this court came in.
Indeed, so my lady. And also, by doing that, they are also not pointing to what is the marital regime. One should be able to consider that if you are alleging the benefit, what is the marital regime? They are silent on that. So all I'm saying, my lady, is that they are parading these narratives without giving flesh to these narratives that they are parading, which is very, very, very unfortunate, my ladies. So, my ladies, the question is now on the issue of the Chilwane, which I was going to go to. Is it fair, again married to the presumption of innocence, Article 12(1)(d) of our Constitution, the presumption of innocence? Is it fair for children aged 13, 10, and 5 to be deprived of the love and attention of their parents when the state has not been able to show that they have a prima facie case which would empower them to keep my client in custody for these 7 months? The answer is a resounding no. Obviously, it is not fair. And my learned colleague realized that's why he withdrew the OISEP case. It is not fair. So what we are saying, Your Ladyship, is that for the past 7 months, my client's children have been enduring hardship. Being cared for by a nanny and parents is two different things. But of course, this court has this opportunity to correct the wrong that was done. Actually, the 26th of September 2025, when the judgment in this case was passed, it was a sad day in our jurisprudence. But of course, this court will be able to correct it. I'm saying so because, my ladies, from paragraph 2 of that judgment, already labeling this case pure rot, already shows that whatever follows is fruits of a poisonous tree. In other words, the mind of the magistrate was already made up. He's saying what the public have come to label this case as pure rot. That means he also subscribes himself to that term. Now, how do you subscribe yourself to that term before you even go into the merits of the bail application? Which shows that you already made up your mind and you are not willing to look at each person's own circumstances and what they've adduced in the bail application, and to be able to come up with a proper judgment, which was supposed to be the case. That was not done. So, what we are saying, my ladies, in conclusion, is that this court, which we have faith in, is seized with the opportunity to correct the wrongs that were done. Because indeed, the 26th of September 2025, that judgment that was passed by Magistrate Samuzala, with respect, was a great travesty of justice. My ladies, this court can end all those dark days and the misery that my client and the other appellants have suffered for the past 7 months. Those are my submissions.
Thank you.
My ladies, you had asked me a question, and maybe to tie in with the submissions my learned friend made, again with the invite that let's end this misery of that judgment. There is a matter of Elias Angombe versus the state. It's a criminal case, my lady. CA 43 of 2012. Justice Smarts presided over that matter as he then was. It was a matter that was heard on the 23rd of August 2012. It was also a matter in which the judgment was delivered on the 23rd of August 2012. So it has happened. In fact, in this instance, the appellant was denied bail. And he had his fate then and there. My ladies, tying in with the submission my learned friend made, if it is that this court is not with us, even so, my ladies, it is in the interest of justice that the appellants be put out of their misery of not knowing whether they are going home or not. Because, my ladies, you must appreciate that there is also a psychological paradigm that goes with the proceedings before this honorable court. Particularly, where there are interests of minors also at stake. And this honorable court is no doubt the upper guardian of minors. Those are my submissions. I hope that helps in elucidating the strong submissions made for putting us out of our misery, my ladies. It's a court, please.
Thank you. At this stage, the court is quickly going to stand down. We will convene shortly. We will
Reconvene.
reconvene
Within 10 minutes.
within 10 minutes.
As a court, please.
Thank you.
Elucidate, my brother. Elucidate.
Let's make it strong. So? Yeah.
Let's see.
There's no parking in the room.
Je weet het daarom te getellen wordt. Je weet het daarom te getellen
Elucidate. Let's quickly just take our phone. Yeah. Yeah. Elucidate. Yeah.